When is it legally justifiable to shoot somebody in self-defense under South Carolina law? So in other words, when can you defend yourself using deadly force? The easiest way to remember this is to think that you fight force with force. So how much danger are you in? Now there are a couple of things that play into this, and anytime you talk about the law, it gets a little bit more complicated. And as a lawyer, even if a lawyer's answering a question, we've got a couple of exceptions knocking around in our head. So, but to make it simple and understandable, you're legally justified in shooting somebody and using deadly force because that's what you're feeling threatened by. In other words, you feel an immediate and realistic threat, like I'm about to be killed. This person is going to kill me. If I don't do anything, I'm dead. But not only that, but I'm dead now, because an assault is when you're being assaulted, and assault and battery are two different things. The assault is that you're in fear. I could assault you and never hit you. Okay, that could be an assault where you think I'm about to kill you, but I never hit you, I never shoot you. I'm not able to because you intervened. You did something. So let's say you have a gun that you lawfully have and you use it to defend yourself. Like I never got a shot off. I wasn't able to push you off the cliff, but I was trying. So an assault in the law in South Carolina is you have this imminent fear of harm, and the person who you're afraid of is physically capable under those circumstances of doing that harm. So it has to be immediate, has to be imminent. So if you're not in fear of losing your life, then you're not justified in using deadly force. And shooting somebody or shooting at somebody is using deadly force. Now, there are legal exceptions to that. For instance, under the Stand Your Ground law, the Castle Doctrine is also called, if you're in your house, the law presumes that the person trying to come into your house is armed with deadly force. So the presumption is you could always shoot them. Now, that's the law. Sometimes the law and reality and the way things are handled by police and prosecutors, they don't exactly match up like a perfect puzzle. The other thing is that if you're in your car in a public place, the law in South Carolina now treats your car the same as it treats your house. They've treated your house this way for centuries, but now your car, that if somebody's trying to get in your car, trying to assault you in your car, under the law, the presumption is that person is armed with deadly force. Whether it's true or not, you have the right to use deadly force to defend yourself. Now, in the real world, if somebody is trying to get into your car and you shoot them, and either they die or they don't die, and you're going to get arrested, you're going to be questioned if you shoot somebody, regardless of the law. So now what happens with that? That's what you have to worry about, because now the investigators and people that are going to prosecute you start picking this thing apart and saying, well, was it reasonable for you to think the person was trying to intrude into your car to harm you? What about that was reasonable or unreasonable? And that's the issue that you get into. But basically, you have the right to shoot somebody if you're in reasonable, imminent fear that you're about to lose your life, and that's what they're doing. They're trying to harm you.